In recognition of Dorothy Thompson's contributions to the field of human rights on campuses in Kansas and throughout the United States, the university has established this lecture series. Dorothy was associated with K-State from 71 until she died in 92. And from 72 to 85, she was the affirmative action officer and director here at K-State. Then she took a leave of absence from her affirmative action post and went to Osborne Law School, where she graduated 13th in her class. And then in 1985, she became the associate university attorney. She served on the Law Journal board at Washburn and as president of our local bar association, and she was admitted to all the courts, including the Supreme Court. She was highly regarded by persons of all political leanings, which is a little unusual, for her diplomacy and her judicious qualities and effectiveness. And she respected everybody. She had a profound commitment to fairness and equity. So a civil rights series like this is a particularly fitting memorial to Dorothy. I think I was asked to give this introduction because I knew her for a long time. She, in various relationships, she was first my client while I was university attorney, and she was affirmative action director. Then she went to law school and became my law partner downtown in my part-time private practice. And then she joined the university attorney's office as my colleague here at K-State. So I had all those different experiences with Dorothy over a long period of time. She was an excellent attorney. She was a very determined and hard fighter for her client, but she was always polite. She was always calm. She was always respectful. So, you know, this could be a series about civility as well as a series about civil rights. And now I'd like to turn it over to Ruth Dyer, who's our senior associate provost, who will introduce our speaker.
Good evening, and welcome to this prestigious lecture series. I'm delighted to introduce Stanford University Law Professor Richard Ford, who will present tonight's Dorothy L. Thompson Civil Rights Lecture entitled Rights Gone Wrong: What is the Meaning of Equal Justice for All? Professor Ford received his law degree from Harvard Law School, where he was a Reginald F. Lewis Fellow. Later, he practiced law with the firm of Morrison and Foerster. He has served as a housing policy consultant for the city of Cambridge, Massachusetts, and also as a commissioner of the San Francisco Housing Authority. He joined the Stanford Law faculty in 1994. As a professor and public intellectual, Professor Ford has challenged widely held beliefs on affirmative action and racism. Writing for both the popular and the academic press, he has focused attention on our nation's stance on many critical issues of race, multiculturalism, and diversity. Professor Ford helps his readers distinguish appropriate complaints of prejudice and bias from those that are exaggerated and invalid. He has argued that by misunderstanding the meaning of discrimination, our courts have oversimplified problems of inequality and misdiagnosed social ills. He has published articles in the Washington Post, the San Francisco Chronicle, the Christian Science Monitor, and regularly contributes to Slate magazine. He also has published 4 books in this area: Universal Rights Down to Earth, The Race Card: How Bluffing About Bias Makes Race Relations Worse, Racial Culture, A Critique, and Rights Gone Wrong: How Law Corrupts the Struggle for Equality. Please join me in giving a very warm K-State welcome to Professor Richard Ford.
Hello, thank you. I'd like to thank you all for coming to hear me speak today, and Kansas State University for inviting me for this lecture. I'm quite pleased and honored to be here and speak to you today. I tend to pace law professors pace up and down, so you'll forgive me if I walk up and down rather than stand behind the podium, but the feet and the mind tend to work together. And so I'm here today to talk to you about arguments that come from my recent book, Rights Gone Wrong. And I want to frame this for you by suggesting that it seems to me that most people, when they think about rights, think of them as pretty much an unqualified good thing. And certainly civil rights are good, and more civil rights are better. And the typical understanding among both the person on the street, lawyers, judges, is that if we expand the tradition of civil rights, if we grant more rights in more areas, and if we are more forthright and more steadfast in enforcing rights, then the kinds of social injustices and social problems that we've confronted in the past and continue to confront today will eventually go away because of our resoluteness about enforcing rights. And I want to suggest that that's not quite true, that in fact sometimes rights work extremely well in order to fix social problems, and other times they're the wrong tool for the job, and other times they can actually be counterproductive and make it harder for us to see the social problems that confront us and make it harder for us to deal with those social problems. Civil rights, after the civil rights movement of the 1960s, one thing that we saw was that civil rights were remarkably successful in certain areas of social and economic endeavor. So for instance, in the area that we lawyers call public accommodations, lunch counters, restaurants, movie theaters, we passed the Civil Rights Act of 1964, which required the desegregation of these areas, required them to be open to all without regard to race. And that was remarkably effective very, very quickly. I think it's fair to say that it was more effective more quickly than most people who supported the legislation thought it would be. That many people thought, well, you'll pass this law, but people will resist, whites will stay home, there'll be problems. And in fact, that stuff didn't happen. The businesses changed their ways relatively quickly, and public accommodations are now open to everyone. So that when I tell my students this, that my parents, for instance, had to think about where they'd stay as they traveled across the American South, because many hotels wouldn't be open to them on account of their race, that they couldn't just count on pulling into the nearest motel and staying there, because many of them wouldn't accept blacks. My students look at me as if I've come from another planet. That's not the planet on which they live, and that's a great thing. And it's a remarkable accomplishment of the civil rights movement. In areas like employment, civil rights laws have been a mixed success. Certainly, blatant practices of racial discrimination have gone the way of wooden shoes. You no longer see employers that say blacks need not apply, or no, I don't think we'd take a woman for this job. But in fact, over 40 years after the Civil Rights Act, there's still evidence that women make, in many fields, 75 to 80 cents for the dollar that men make for comparable work. There's still many, many workplaces across the United States which are effectively segregated, in which one can tell that certain job categories appear to almost be reserved for people of particular races. And there's still many, many instances of individual discrimination that are reported. And so the laws have been a mixed success. And I'll talk a little bit at the end about some of the areas where we still need to do more. And then there are areas where the civil rights laws haven't worked very well at all. So for instance, housing. In the Fair Housing Act was passed in 1968, and many people expected that we'd see the kinds of dramatic and rapid changes that we saw in the areas of public accommodations, but that's not what happened. And in fact, the isolation of poor minority communities in the United States today is in many ways worse than it was during the 1950s and 60s. So civil rights laws haven't done much. That's been one that they barely made a dent in the problem. And even in the area of education, where the landmark decision in Brown versus Board of Education, one of the most celebrated decisions in the civil rights pantheon, it mandated the desegregation of the nation's schools. But today, schools in the Northeast and Midwest, we still have schools where 1/4 of African American students attend schools that are almost entirely black. So segregated schools, as a matter of fact, continue even as segregation as a matter of law has been eliminated by legal rights. And in fact, the degree of isolation in the public schools of minority groups, blacks and Latinos, has actually worsened since the 1980s rather than gotten better. So we have a bit of a paradox in which on the one hand, racial attitudes by and large are getting better. We have a black president. If you poll people, their racial attitudes are better than the last generation. Some of the racial problems are getting worse. And what I'd like to suggest to you is that part of the problem is that we've looked at civil rights not as a tool in order to address social problems, but instead as the only way that we address social problems. And so we tend to, and lawyers are more guilty of this than most, we tend to hammer away at a problem. To a hammer, every problem is a nail, and to a lawyer, every problem is a civil rights violation. And so we promulgate more and more individual entitlements in order to deal with social problems, when sometimes an individual entitlement is not a good tool for the job. It's like taking a hammer to a wine bottle. It may be a great tool in order to drive a nail, but it's not such a good tool to open a bottle of wine. And if you use it for that purpose, you might do more harm than good. Now, I'd like to give you a few examples of how this has happened. The first one's going to be kind of a fanciful example, so bear with me. I hope that you'll bear with me as we move into the more serious example. In 2008, the Californian filed a civil rights lawsuit to stop Mother's Day. And here's what happened. Here's the dispute. In 2005, the California Angels baseball team held a Mother's Day celebration in which it handed out goodie bags, pink goodie bags that said #1 Angels Mom, to all of the women that walked into the ballpark. Now, they didn't try to figure out which women were mothers and which weren't. They just gave a goodie bag to all the women, but none of the men. And he sued the team for sex discrimination based on the fact that he didn't get a fetching California Angels mom goodie bag. And the case got to court. Now, it turned out he lost that case. The court said that the team was discriminating not on the basis of sex, but on the basis of motherhood, and just used sex as an easy proxy. It's a biological fact that only women can be mothers, the court opined. The Angels did not arbitrarily create this difference. And instead, this is Mother Nature, in other words, the law of nature, not a violation of civil rights laws. However, his lawsuit wasn't as crazy as you might think, because it turns out that in many states in the United States, including my home state of California, ladies' nights at the local bar are, in fact, a violation of civil rights laws. In 2007, a New York attorney and men's rights activist, Roy Den Hollander, filed sex discrimination suits against 5 Manhattan nightclubs that charged women less than men under ladies' nights promotions. In 1979, Anaheim, California student sued when he's excluded from a bar that admitted his female companion on a ladies' night, and later also sued a gas station that had a ladies' day that gave a cheaper car wash to women than men. And he actually won those lawsuits. States as numerous as Colorado, Iowa, Pennsylvania, Connecticut, and Hawaii have found that ladies' nights are a violation of their civil rights laws prohibiting sex discrimination. So, how did we get to the point where laws against sex discrimination that are designed to confront real and serious problems, like that 80 cents on a dollar I was talking to you about, that women get for comparable work as compared to men, wind up being used in order to limit ladies' night at the local bar? Is it really the case that if we're going to have laws that prohibit lecherous bosses from abusing their female employees, or sexist bosses from discriminating against and limiting the opportunities of women, that we also have to get rid of ladies' night? Now, here's what the California Supreme Court had to say. And one thing that you'll notice here is that this isn't a story about liberals or conservatives. It's liberals and conservatives. It's a story about a legalistic mindset that's taken hold of the culture, and that I'm afraid people in my profession have done a lot to promote. The California Supreme Court Justice Rose Bird said in attacking ladies' night and finding that it was a violation of civil rights laws, that the legality of the sex-based price discount cannot depend on subjective value judgments about which types of sex-based distinctions are important or harmful. In other words, if we're going to say that it's unlawful to discriminate against your female employees in their wages, we also have to say that it's unlawful for the bar to discriminate in what they charge the patrons coming in on ladies' night. We can't make these kinds of value judgments that one's trivial and the other is significant. So I want to put it to you whether you think that's the case, and to suggest a few reasons why we might not think it's the case. There are many instances in which we do allow discrimination. For instance, men's and women's bathrooms. And now one might say, well, if it were a black's bathroom and a white's bathroom, that would clearly be a violation of civil rights laws. So how can you say that it's acceptable to have these segregated bathrooms for men and women? And if we can't make value judgments on the subjective value judgments about which types of discrimination are harmful and which aren't, then it looks like we've got the men's room and the ladies' room, their days have to be numbered under civil rights laws. But in fact, of course, that's not what we do. And the reason why we don't do it is because judges do make value judgments about which types of discrimination are harmful and which are not. It's because it's necessary that we make such value judgments in order to make the laws actually work effectively. The truth is that we know that we've passed these laws in response to some specific social evils, and we can describe those, the history of sex discrimination in great detail. And Ladies' Night probably doesn't fall into the category of the kind of social problem that we need comprehensive legislation from the Congress to confront, or from a state legislature to confront. But the job discrimination that I described earlier does. So my suggestion is that we need to make such value judgments after all. Now I'd like to move to the more serious case. Because one might say, and with some justification, well, who really cares whether we have ladies' nights at the local bar or not? It might be a little bit silly, although I would suggest to you that these kind of trivial and frivolous applications of civil rights law do some damage, that they do fuel skepticism about the entire project. That when the ladies' night case was reported in the media, many people said there's another example of the overreaching of civil rights attorneys trampling on the common sense, and et cetera. And so there is some damage that can be done by bad applications of civil rights law, other than the fact that now on Thursday nights you're going to go to a bar that's packed with men because the bar can't have ladies' nights. But more serious example, Brown versus Board of Education, the most important, arguably the most important civil rights opinion in the constitutional pantheon, and certainly the case that most people see as the beginning of the end of Jim Crow and as a landmark in the civil rights struggle. As it turns out, on Brown's 50th birthday, we heard a lot of celebration about how far we'd come as a nation, about how we'd overcome the prejudices of the past. But what was less well advertised is that in 2006, on the roughly the 50th anniversary of Brown, 2 of every 5 Black and Latino students attended a school that was over 90% non-white in schools in the Northeast and Midwest, according to the Harvard Civil Rights Project. Moreover, 1 year after that, in 2007, the legal precedent that was used in order to desegregate the schools in Brown versus Board of Education was deployed in 2007 in order to prevent the integration of public schools in a case called Parents Involved in Community Schools versus Seattle School District. And so I'd like to walk you through how we got from Brown versus Board of Education and the principle that the Constitution requires desegregating the schools to Parents Involved and the principle that the Constitution forbids desegregating the public schools. It's a little bit of a walk, so bear with me. When desegregation first started after Brown versus Board of Education, in 1954, right after the Brown decision was decided, guess what happened in Southern schools that had previously been segregated? The answer is nothing. In fact, nothing is the answer for about 10 years. So in 10 years, very little change in Southern schools. In fact, the year after Brown versus Board of Education, when in ringing language, the Warren Court said that the schools would be desegregated with all deliberate speed. Some of you may have heard this phrase, all deliberate speed, which sounds quite heroic and quite steadfast, was in fact a way to delay the desegregation of the schools. It was to say all deliberate speed, meaning not now, but after we work out some details. And so there was 10 years of delay, and actually what got the schools desegregation moving was when the Civil Rights Act allowed the Department of Education to tie federal funding to the desegregation of the public schools. Then the litigation actually had some bite and some things started to change. Now what happened after 1964 was and many of you may be familiar with this, some of you may not, we began to have a series of decisions that required not just removing the formal barriers to desegregation, but also ensuring that those formal barriers weren't reproduced through informal means. So the school district that once said we have a black school here and a white school there might later say, well, what we'll do is we'll have a school that's in theory open to people of any race, but everyone goes to the school that they went to last year. And so it's a race-neutral rule. But the effect, of course, is to keep the segregated system in place. And so the courts had to get a little more assertive in dismantling this dual school system. And the ultimate result of that process, which ironically was a result of the delay of all deliberate speed. That's when the court started to notice the various ways that school districts had to get around actually dismantling the dual school system. But at any rate, the ultimate result was to have fairly assertive desegregation plans that in some cases required long-distance busing of children across town in order to ensure that the schools were in fact statistically desegregated. Now this was an important thing to do given the backdrop and given the recalcitrance of many of the school districts. But it did have some unintended and unfortunate consequences. Many people began to resist desegregation, not just because they resisted racial integration, although that certainly was part of the problem, but also because of the much more natural and universal parental impulse not to want your children too far away from you, too far away from home, bussed across town into a neighborhood with which you're unfamiliar. And so desegregation got some additional baggage as a result of the way the desegregation programs were implemented through litigation. In addition, because the desegregation was implemented through litigation, the orders developed by lawyers and judges very often didn't pay as much attention as they might have to the conditions on the ground. And so, for instance, in Boston, and so some of the greatest resistance actually is a little less well known than the resistance in the South, which is of course quite well known, is that much of the worst resistance to school desegregation came in the North, in cities like Boston, where the whites boycotted public schools in response to desegregation. White mobs threw stones at school buses carrying children from the predominantly black Roxbury district, and protesters in fact planned to overturn and burn school buses carrying black students. So there was a great deal of very, very violent resistance to desegregation, and as a result, many people in the communities, both black and white, said, let's take a step back and find other mechanisms to achieve integration at a pace that people will accept. And indeed, many black parents in Boston, according to Derek Bell, a civil rights lawyer at the time, said they didn't want to back away from desegregation, but they did wish to place greater emphasis on upgrading their own schools' educational quality and to minimize busing to the poorest and most violent white neighborhoods. But the lawyers in charge of the litigation would have none of that, and in fact pushed for the most aggressive desegregation plans possible. And Derek Bell writes quite eloquently about how that decision was responsible for a kind of a schism between members of the community in many cases and the civil rights lawyers. And so, based on the strict legal principle, the strict letter of the law, the lawyers were right. We have to desegregate it, and the fact that people are resisting it, that shouldn't be an impediment to vindicating the civil rights of the individuals to a desegregated education. But as a practical matter, there might have been ways to smooth the effort and make it more palatable to all involved. Now, these practical impediments eventually made it difficult to achieve desegregation in many of the most segregated areas. So as time went on, what happened was we got school districts that became, the entire school district was predominantly non-white. So it's one thing to try to integrate a school district where you've got 50% white and 50% black, or 80% white and 20% black. It's another thing to try to integrate a school district where the school district is 82% black or 95% black. And that was the situation that you began to face in the 1970s in cities like Atlanta and Detroit. Now in Detroit, because the school district was predominantly black, in fact so overwhelmingly black that desegregation within the city limits of Detroit was impossible, the federal courts decided to join the school district in Detroit with surrounding suburban school districts and have even longer distance busing. To bus kids from the suburban districts into Detroit and from Detroit out to the suburban districts. And this is a map of the racial demographics of the Detroit area, and so you can see how stark the racial separation in fact is. Now, the Supreme Court eventually backed away from this. So the Supreme Court decided, well, no, we can't do that. We can't require school districts, the suburban school districts that had never participated in legally enforced segregation, to join in the remedy. And so, in many ways, this was a significant step back from Brown versus Board of Education. In fact, one of the lower courts said that if they were to block the desegregation between school districts, it would open a way to nullify Brown versus Board of Education. That was the language of the court. And in fact, the Supreme Court did exactly that. They said, we will block that kind of long-distance busing. Now, it may be that the court had become aware of the practical limitations of engaging in this kind of busing. But what I want us to notice is that we begin with a strident enforcing civil rights in the early cases, even when both black and white communities are uneasy about it, but we wind up with a real scaling back. In the case in Detroit, which was a case called Milliken versus Bradley. And the reversal continues, because Milliken was just the beginning. By the 1990s, the federal courts were busily deciding that school districts had fulfilled their obligations to desegregate, that they had achieved what the courts called unitary status, and therefore, rather than operating a dual school system, they were now operating a unitary school system, and therefore we could wind down the desegregation efforts. And the reason for the statistics that I gave you earlier on, where schools are now steadily resegregating, is in large part because the federal courts have decided that the school districts don't need to continue the effort. Now, I'd like to move us forward to 2007, where we faced a conflict involving two school districts, both of which had been accused of racial segregation in the past, both of which had engaged first in court-ordered or court-enforced desegregation, and then later voluntary desegregation plans. So the school districts in Louisville, Kentucky, and Seattle, Washington, both had adopted voluntarily at this point, because the court orders had expired and were no longer enforced, plans to desegregate the schools. And these plans were relatively mild. They didn't involve long-distance busing or any of the things that had created the kind of backlash in Boston. Instead, they were plans that involved magnet schools and using race as a tiebreaker in cases where two applicants were otherwise equally qualified and one would contribute to the racial integration of the magnet school and the other would not. Those plans were challenged under the 14th Amendment, the same constitutional provision responsible for Brown versus Board of Education. And what the Chief Justice of the Supreme Court, then John Roberts, said was at one point, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. A nice, clean, bright line rule. And he quoted from the arguments of the lawyers in Brown versus Board of Education when they said, no state has any authority to use race as a factor and affording educational opportunities among its citizens. And so, using that language, the Supreme Court said, well, these school districts in their voluntary integration plans are using race as a factor in assigning educational opportunities to their students. That's exactly what the lawyers in Brown said they couldn't do. And echoing Rose Bird, when she talked about sex discrimination, Justice Clarence Thomas, in his concurrence, said, can we be so sure that we can tell the difference between benign and malign uses of race? I'm not so certain, and the Constitution doesn't allow it. So, we can't tell the difference between Jim Crow segregation and a voluntary integration plan. We can't tell the difference between blatant sex discrimination in wages and ladies' night, and therefore, the only way to stop discrimination on the basis of race is to stop discriminating on the basis of race. The same law that requires us to integrate the schools in 1954 forbids us from integrating them in 2007. That's where we've wound up in this kind of strange reversal of civil rights laws. And I'd like to argue that that's a case of rights gone wrong. Is there an alternative? I think so. And that alternative was identified by some of the judges in some of the early civil rights cases involving busing. In which they suggested that administrators, school administrators who have competence and experience in school administration might be able to work something out in the best interest of all involved. Now, of course, the problem in many instances was that the school administrators at the time of Brown versus Board of Education weren't interested in working something out for the benefit of all involved. They were dragging their feet and opposing any efforts to move forward. But the irony is that when, in 2007, we had school administrators who were hoping to come up with an approach to racial integration that everyone in the community would embrace and could live with, the Supreme Court said they couldn't do it based on an absolute idea of individual entitlement. And that strikes me as a pretty classic case of rights having gone wrong. I want to say just a little bit about a case called Dukes versus Walmart, but not much. But many of you may have heard of this case. The Walmart was accused of sex discrimination in what would have been the largest class action in American history. It was a class that it would have included 1.5 million women. And the claim was that there was a pattern of sex discrimination that was proven through the individual testimony of many women who had suffered discrimination at Walmart, and through statistical evidence which showed that the applicant pool, or the group of people eligible for managerial positions at Walmart, was close to 75% female, but the number of people that actually got the managerial positions was much, much less than that, and in each higher tier of management, you had fewer and fewer women. So there was a huge statistical disparity. Now, they famously lost the capacity to bring this nationwide class action. The Supreme Court said that the class action was too large and that the various cases didn't have enough in common. One of the reasons that this case was so hard to bring was because in today's environment, you don't get the smoking gun or the women need not apply, but instead what you had were a whole series of informal decision-making, very decentralized decision-making by managers at the store level who were encouraged to make decisions based on sort of ineffable qualitative skills like teamwork and integrity. And so when the woman who didn't get the promotion said, why didn't I get the promotion? I have more years of service. I have a better work record. Well, but Joe here has more integrity. And that's something that's hard to dispute in court. But what we had is the statistical evidence that showed that all of these decisions, even if some of them may have been justified, it's very unlikely that all of them were. And so the statistical disparity showed us that something bad was going on. What I want to suggest is that the approach with individual civil rights entitlements isn't a great way of getting at this problem, because no individual woman can show that she was actually the victim of discrimination. In some of the cases, Joe really did have better people skills or integrity. It's just that we don't know which ones. But what we do know is that there's a problem systemically, and we could address that problem through more systemic or comprehensive style regulations rather than through individual lawsuits. So my suggestion in moving forward into the next century for civil rights is that a better approach might be to suspend not abandon, but suspend the commitment to an individual entitlement in every case and shift our focus to public policies designed to promote equity overall. That if we could get companies like Walmart to change their day-to-day practices so that we saw more equity overall in the way they were making their decisions, that would be a better approach than saying that this woman or that woman has a right to sue in a context in which the individual woman is very unlikely to be able to prove her lawsuit. And because more and more of the social problems that we face today take this form, not the form of the blacks need not apply, not the form of the women need not apply, but instead this much more subtle form, that this is probably the only way forward. But in order to do it, we'd have to move away from the notion, one, that the only way to deal with the problem is through civil rights and individual entitlements. We'd have to move away from the idea that we can't make value judgments and tell the difference between benign and malign forms of discrimination and move toward a more collective approach. And that's what I would propose as the way forward today. Thanks for your time. So, what's next? Okay, great.
Thank you, Professor Ford. I think that all of us would agree as we sit here and we listen to the persuasive arguments that Professor Ford has made about rights, that for each and every one of us as we process this information, as we think about what we know and how it is that we feel about civil rights, it's very individual. And we each have our own opinions about where this fits into our lives and into the lives of into society. So what I'd like for you to do is take just 2 minutes individually, and you should have at your table a so what, now what? You know, you came and spent, 35 minutes sitting here, especially for those of you that are young, that have all types of homework to be doing back at your dorm or your apartment. So you've spent some time. I want to know what it is that these persuasive arguments that Professor Ford has made, what did they make you think? What did they make you feel? So just for about 2 minutes, bullet a couple of feelings. If you're indifferent, just go ahead and put, I'm indifferent to what was shared tonight. If you're confused, what are you confused about? And then a thought that you had. Once the 2 minutes are up, and I'm going to stop talking, then you're going to, as a group, as a team, as a table, share those out, and then come up with one question that you would like to ask him. And this is once-in-a-lifetime chance to have this very articulate gentleman here sharing his, what he knows about civil rights, and he's written. So we're very lucky to have him in Manhattan. So I want everyone thinking for the next few minutes. 2 minutes, I'm not talking anymore. And everyone should be writing. Some feelings, a thought that you have. Here you go.
Okay, so thanks so much for your questions. I only have a chance to address a few, but I'm going to try to kind of clump them into groups. There were several people that asked in one way or another, how do you fight subtle racism? How do you fight institutional racism? What can we do in order to deal with these more subtle problems? And I think that there are several things that we could do. My suggestion is that if we started to take an approach that involved comprehensive policy, so let's take the case of employment, where you have a company like Walmart, and what we're dealing with is subtle and institutionalized bias against women. And we don't have a smoking gun, and in many cases we might not even have someone who we would describe as a sexist, but we have this outcome. That the approach of individual entitlements isn't going to get us very far, but what would be an EEOC, the federal agency in charge, that's now in charge of enforcing anti-discrimination law, but doesn't have very much power, that effectively now just vets individual complaints for the most part, and occasionally takes one of those individual complaints and sues on behalf of the complainant. What if we had an EEOC that had the power to actually intervene in workplaces and give incentives to change the day-to-day practices of the workforce, or even, in appropriate cases, issue fines and cease and desist orders. So, for instance, an easy case would be to say, we see this significant statistical disparity between your promotions and your workforce, and we expect to see change over the next 5 years. We don't care how you do it, but we expect to see significant change, and if we don't, there'll be a fine attached. That would be a way of letting the business, giving the business the incentive to root out the problem in its own workforce, but giving them a powerful incentive to do so. Another possibility on the carrot side would be to say to businesses, if we know the types of practices and policies that are most likely to reduce or eliminate discrimination, and you're willing to adopt them voluntarily, we'll give you immunity from certain types of civil rights lawsuits, or we'll allow that to be an affirmative defense, as we lawyers call it, to civil rights lawsuits, so that you can demonstrate that, we did everything we could in order to deal with this problem in advance. And we have a little bit of precedent for that in some areas. In particular, in the context of sex harassment, the Supreme Court has said that a workplace that adopts an effective anti-sex harassment policy is able to assert that as an affirmative defense. Now, it's not an absolute defense. They have to show that it's effective, and they have to show that the plaintiff in question refused to take advantage of it unreasonably. But it's a way of getting the employer to change the day-to-day practice rather than wait for a lawsuit and then try to correct the problem after the fact. So those are the kinds of things I would think about. Several other people also ask about the criminal justice system in various ways. And I think there's another example in which a comprehensive approach would work a lot better than individual entitlements. So in my book, I write about the Gina 6 controversy. And one of the real problems in the Gina 6 controversy was that the Gina 6 were standing in some sense, for the huge problems in the American criminal justice system, the huge disparities in race, the way that young black men in city after city are railroaded into prison by overzealous prosecutors, and by a criminal justice system that since the 1970s has gotten increasingly more punitive. Now, the problem is complex, and one of the things you'll notice is that as the problem of cradle to prison movement in African American communities, particularly among black men, and the problem of the just staggeringly high incarceration rates for young minority men have increased, racial attitudes have gotten better by every reliable sociological account. So it's not plausible to say that the problem is due to increasing racism. It's not plausible to suggest that racism today is worse than in the 1950s. Or the 1960s, when the problem was much less severe. So what is the problem? Well, it's complicated, but it includes things like a general law and order crackdown that's fallen with greater force on minority communities. It includes the way we reward prosecutors and police for rates of arrest, rates of incarceration, rather than rewarding them for taking a more nuanced view and perhaps improving crime in other ways. It has to do with systemic incentives, and those could be changed. An easy solution, get rid of the war on drugs. What we see is that it's a huge amount of the incarceration of minority communities is due to petty drug crimes. And petty drug crimes that in every other country are punished as mild infractions that don't involve imprisonment at all, and that used to be punished that way in the United States. The war on drugs hasn't helped us get rid of drugs. It has created the largest incarcerated population of any country in the civilized world, and without much payoff, and it's created a huge racial disparity. And most of the relevant data shows that the racial disparities are most pronounced in drug crimes. So several studies have demonstrated that for violent crime, for the crime that you're really worried about, the racial disparity isn't that great. So the criminal justice system is probably, at least in terms of race, doing an okay job when it comes to murderers and rapists and the kind of criminals that we really all ought to be afraid of. But when it comes to low-level drug crimes, there's a huge racial disparity that operates throughout the criminal justice system. And just focusing on that would get us a lot of distance without having to prove that anybody's a racist, because that's a tough sell. And getting a prosecution overturned because the jury or the judge or the prosecutor was biased, the most I can say is good luck. Even in the case of the Gina 6, it wasn't entirely clear that the problem was biased prosecution as opposed to overzealous prosecution. And so it turned out to be not a perfect example of the problem, but there is a problem, and we could deal with it through more comprehensive reform. So that's going to be my answer to most of these kind of questions, that we do know what works to some extent. We do have expertise about how to correct some of these problems, but we need political will and we need the incentive to get it done, and that would require changing some of our institutions. Let's see. Were there any other questions I should look at, or are they pretty similar?
What are the issues of the Voting Rights Act is one that was different?
Okay, yeah, that's interesting. Well, there are a lot of issues. The Voting Rights Act is one of the most important pieces of civil rights legislation. It was passed in response to a series of practices that occurred in the United States that kept people of color from exercising the franchise. Some of those practices were just straightforward voter intimidation, blocking people from the polling places, and that type of thing. And we still see that sometimes goes on. I mean, some of the controversy around poll watchers in some parts of the United States really involved people that weren't just watching the polls, but that were intimidating voters to keep them out of the poll and keep them from exercising the franchise. But the bigger set of questions involved practices that, in which congressional districts or voting districts were rigged in such a way to dilute the voting strength of certain groups. And it would take a while to get into all the technical details, but basically we draw electoral districts and then a representative comes from each district. The districts are redrawn every 10 years in response to the census. Because they have to be of equal population, so we redraw them. When you're drawing those districts, if you're savvy and you have a good map and some good computers, you can figure out a way to rig the districts in order to help the people that you want to win, and the people that you want to lose. Now, everyone understands that this is done all the time in the context of political parties. And it's actually perfectly legal and constitutional to do it in the context of political parties. So if you're the political party in charge, you can draw the districts in order to help the people in your party win and make sure that the people in the other party don't get as few seats as possible. But that was historically done, particularly in the southeastern states, in order to disenfranchise blacks. So you'd rig a district so that if you have a population where there's 30% black, and 3 districts, let's say, and you'd expect to have 1 black representative and 2 white representatives, you can draw the districts in such a way that the blacks are 30% in every district, and so they can't elect anybody. And there are a variety of tricks that had been done in order to disenfranchise blacks in that way. So the Voting Rights Act was designed to correct for that. And the big controversy right now is a provision of the Voting Rights Act which requires certain jurisdictions that had a history of engaging in these types of practices to pre-clear any changes in their voting laws with the Justice Department. So for some districts in the United States, and most of them again are in the Southeast, that before they can make a change to their reapportionment, before they can make a change to anything that involves the exercise of the franchise, they've got to go to the Justice Department and pre-clear it. And right now, the controversy is whether that's still needed, whether it's fair to say these states we don't trust, and these states we're going to go ahead and let do whatever they like until they get sued. That's the question there. And to my mind, there may well be jurisdictions that currently have to have Section 5 pre-clearance that shouldn't. Things have changed. But I'm certainly not convinced that there are no jurisdictions that need Section 5 pre-clearance. And I think in the last few elections, we've seen sufficient examples of these kind of practices that have continued to make me convinced that the Voting Rights Act and the pre-clearance provision are still necessary. Let's see. Oh, several of you asked why I wrote the book. And I wrote the book in large part because I saw time and time again the civil rights tradition being deployed or twisted or perverted and used in ways that were either in direct contradiction to its original purposes, or used in ways that really didn't foster social equity at all, but instead were either abused by opportunists, abused by ideological extremists, or used in ways that kind of trivialized the real social concerns. And so that and what I saw was that as we had a growing number of civil rights cases and a growing sentiment in the country that we have too much litigation, that we have too many people complaining and griping about their rights, we've gone too far, that at the same time the problems weren't being solved. And so the problems continue, which gives us more and more pressure to have more civil rights and gets more people frustrated and of the view that we've gone too far. And it struck me there was a disconnect, and that very few people were willing to acknowledge that sometimes a legal entitlement is a bad tool in order to fix a social problem. That is, as proud as we are and as proud as we should be of the accomplishments of the civil rights movement and the way that civil rights legislation and litigation has done great things, we also have to acknowledge that sometimes it's the wrong answer, that there are a lot of social inequities, that there are a lot of social problems that really aren't civil rights issues and aren't going to be well addressed by civil rights legislation. And if we try to address them in that way, we buy ourselves into a lot of unnecessary waste and expense and frustration. And so it seemed that something like this would be a useful contribution to the dialogue that's typically taken the form either of do we have too many civil rights or not enough, those two poles. And I think the answer is some of both. It's a great question, and I'm afraid that I think the short answer is no. That there's really not a way to do that with civil rights. And it brings me back to the point that civil rights are a limited tool. That if we think of civil rights rather than as a magic bullet or a profound moral statement, and instead look at them as a tool, they're a piece of policy, they're a way to get something done. Sometimes as a tool they work really well, as in the context of public accommodations. Sometimes as a tool they don't work very well. Sometimes as a tool they can be misused. And so we need other policy interventions in order to deal with social inequity, not just civil rights. That's one thing. The other thing about making everybody equal all the time is that we have profound and important and legitimate debates about the limits of equality and the desirability of equality on all bases. So in this respect, I'd like to leave you with a little story. There's a story by Kurt Vonnegut called Harrison Bergeron. And it's a story it's a science fiction story. It takes place in the future. And it's in the future after the passage of, I don't know, it's something like the 29th and 30th Amendment. Everybody was equal. Not just equal before the law, but equal in every which way. And he created the character of the handicapper general who came along to make sure people were equal so that people who were too smart had to wear an earphone that buzzed in their ear to distract them. So it brought them down to they couldn't concentrate. And it brought them down to the level of intelligence of the average person. And people who were especially strong had to carry weights so that they weren't, by the time they were effectively the same strength as anyone else. And people who were too beautiful had to wear a bag over their head so that they wouldn't make other people feel bad or like something that the cat drug in. And we don't want to move into the direction of the handicapper general. So there's a hard question about which inequalities are acceptable and which aren't. I think that when we're looking at something where we've had a history of vicious discrimination like race, like sex, that the answer is easy. In some other areas, the answer may not be so easy. So I don't think the goal is equal in every which way, but the goal is to address the real, blatant, and obvious injustices that have been a part of the nation's history for so long, and to deal with those as distinctive social problems, and they're not all the same. So that the answer that's right in race isn't the same as the answer that's right for sex, or the answer that's right for disability. That's why we say yes to men's and women's restrooms, but we don't say yes to black and white restrooms. Because getting to the right answer requires subtle judgments, not just saying, let's bring everybody down to the same level.
Thank you, Professor Ford. I think he leaves us with lots to think about. Your questions were wonderful, the feelings that you had as you listened to the lecture and the thoughts. So I'm glad everyone had an opportunity to share at least at your table and that we had a chance for a few questions. Definitely have some, take a break and go over and have some lemonade or some brownies. And the book's for sale over here. It is worth reading. And he's going to be signing it for those of you that are interested in having a signed copy. So thank you for joining us tonight, and thank you, Professor Ford.